Namaste. This video is a little different. We're going to talk about whether you can copyright and own yoga moves. We got this idea from a Netflix documentary about Bikram Chaudhry, the founder of Bikram Yoga. It's called Bikram, Yogi, Guru, Predator, because apparently, in addition to being a very famous yoga instructor, he is also apparently a sexual predator. This video is not about that. It's about the general idea of what can you own? What sort of ideas can you actually have property rights and own? I'm Mark Lyda from Lyda Law Firm. Let's get started. It's interesting because the question of what can you own, what ideas and what intellectual property in your own mind can you actually own and have a legal protection over is something that affects way more areas of life than you would expect. And it's a very deep philosophical question about the nature of artwork and technology and what's the best public policy to try to spur innovation and creativity. In this documentary about Bikram, he says, I put these 26 postures and 2 breathing exercises together. They were all existing postures, but I put them in a specific order, just like all the musical notes already exist, but you can copyright a melody where you put notes in a specific order. And the same is true of my yoga posture. So his argument was that he had copyright protection over his postures, just like you would over a song. Interesting side note on that. He also stole the sequence of 26 postures from his teacher in India and just took credit for them and mass marketed them, but that's kind of a side note. So he's had 2 lawsuits about whether he could assert copyright protection over his sequence of yoga postures. The first one settled, but the second one went all the way to the Ninth Circuit Court of Appeals, which is just one stop short of the US Supreme Court. So one of his students started a competing yoga studio that taught the same sequence of yoga postures in a hot room, and Bikram sued this other yoga studio. Bikram lost because the statute on copyright law, the federal law, says that in no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. So, according to copyright law, ideas, processes, systems, things like that are not copyrightable. The Ninth Circuit Court said that the stringing together of these 26 particular postures is just a process. And the idea for that process does not enjoy copyright protection, so anybody can do it without having to tithe to Bikram himself. So they say businesses consist of 3 things: people, culture, and systems. So unless it involves trade secrets or something like that, this does have implications for what business systems you can have copyright protection over. So the 26 postures of Bikram yoga in a hot room, anybody can do that. Anybody can teach that and charge money to teach it. That's why you can go to a hot yoga studio called Hot Yoga, and you can get the same exact class basically that you get at a quote unquote Bikram yoga studio. This was in 2015. And then a journalist named Sarah Jung at Vice.com wrote an article that said that this same principle should apply to APIs. So an API is an application programming interface. It's like a set of procedures for computer code. The Vice.com article was that the principles that applied in the court determining that you could not copyright yoga postures should also apply to APIs in computer code. So there's a huge lawsuit right now that the US Supreme Court is currently considering, which is Oracle versus Google. Oracle is suing Google for using some of its JavaScript APIs. And the question is whether copyright law can protect APIs. Oracle says that APIs are like the chapter titles and point headings that you might see in a book. And Google says, no, they're more like the QWERTY layout of a keyboard, which is not copyrightable. This has huge implications for the interoperability of computer programs, and some argue that if people can copyright and if companies can copyright APIs, that it will make it harder to develop new programs that work together. So this yoga case that determined that yoga postures in a certain sequence cannot be copyrighted actually could have broader implications for technology and artwork. Last point on that is that I thought it was really interesting how the Ninth Circuit described their reasoning in the Bikram case. They said, rather than stimulating artistic creativity for the general public good, copyright protection for the yoga sequence would prevent the public from engaging with Bikram's idea and building upon it. So you can see how that would also apply to computer code. So whenever you have coders in the same room, or artists in the same room, or yogis in the same room, intellectual property can actually be a really hotly debated topic, because we want to be able to protect our creations, but we also want to be able to use earlier creations to create something new on top of it. So if you have any comments or questions about this area, please drop a note in the comments below, or feel free to reach out to us to discuss anything about this case or about intellectual property law in general. Thanks for watching, and please remember to click like and subscribe to help keep legal education accessible for small business owners. I've never been to a yoga class, but I got the idea for this channel from a yoga channel on YouTube called Yoga with Adrian. And the whole idea of that channel is that yoga is something people usually pay for by going to a class. But the philosophy of that channel is that they want to make it free for all, like we're trying to do with dropping legal knowledge.